Now, to save you having to take a note, I intend to circulate after this hearing a note of what I'm going to read out, and that will be provided also to the press, but I haven't got it now because it's pretty rough in the version I'm reading out, so you don't need to take it down. You'll get later today something that is correct but not the final version. The final version, because I'm delivering an oral judgment, will have to be the transcript, the court transcript, which will come, I'm afraid, considerably later. But you will have a document that looks like a draft judgment from which you can rely upon before too long. Only would if my computer was working. Start again. Introduction. We heard oral argument this morning on an application for permission to appeal Mr. Justice Swift's refusal to grant District Judge Katie Thomas, brackets the appellant, permission to bring judicial review proceedings against the Judicial Appointments Commission, brackets the JAC, in respect of its decision not to recommend her for appointment as a circuit judge. We indicated at the outset of the argument that our provisional view, subject to oral argument, was that it would be appropriate to grant permission to appeal and to allow the appellant to bring judicial review proceedings in respect of her claims as to 1, the fairness of the JAC process, 2, the alleged infringement of Article 8, and 3, the proper interpretation of Regulation 30 of the Judicial Appointments Regulation 2013/2192, brackets the 2013 regulations. We said we were not inclined to grant either permission to amend or permission to advance the new ground based on discrimination under Article 14. In correspondence on the 10th of June 2024, and again this morning, we asked the appellant to address which of her 13, quote, amended details of the remedy sought, close quote, she wished now to pursue. We also asked both parties to address, little a in brackets, whether the Court of Appeal should exercise its power under CPR Part 52.8(6) in brackets to retain the application, and b, what directions either party would be seeking as to evidence, timetabling, or any other matter in the event that permission were granted. Having heard oral argument, I would give the limited permission that I've already mentioned, for the brief reasons that follow. In reaching this conclusion, I've borne in mind the importance of this case and the public interest in maintaining a scrupulously fair and transparent judicial appointment process. I recognise that there is much to be said for the arguments advanced by the JAC this morning in terms of the importance of confidentiality for both references given and statutory consultation provided. but I feel that in the exceptional circumstances of this case, the challenges brought to the process by the appellant would be better considered on all the evidence at a full judicial review hearing, rather than being dealt with at an inevitably less detailed permission hearing. The consultation process, as I have intimated, is critical to the fairness and transparency of judicial appointments in England and Wales. There needs to be complete public confidence in it. It is better, therefore, for these challenges to be considered at a full hearing. I shall now proceed to deal in outline with the factual background and procedural history, the reasons for my decision, and the directions that we intend to make. Outline, factual background, and procedural history. The appellant practiced in crime at the self-employed bar and as in-house counsel for a firm of solicitors. In 2018, she was appointed as a salaried district judge. She sat in Walsall County Court. In 2021, the appellant applied to become a CJ, a circuit judge, in each of the jurisdictions of crime and civil in the JAC recruitment exercise. A matter which she felt could adversely affect her application was a formal complaint of bullying, which she had made against a senior male judge, brackets, the judge, in 2019. Pursuant to the formal protocol, the appellant's complaint was sent to the senior presiding judge of the circuit. The complaint led to a meeting with the junior presiding judge, and a decision was made that the appellant would not pursue the complaint as the judge was retiring. The appellant was invited for interview at the JAC's selection day. 3 interviews were held. 2 were scenario-based, and the third was a competency-based panel interview. The civil panel carried out the civil scenario-based interview and the competency-based interview. The panels had before them evidence from the statutory consultee, Lord Justice Haddon Cave, who was then the Deputy Senior Presiding Judge, sought pursuant to Regulation 30 of the 2013 regulations. The appellant does not recall being asked anything of a negative nature. On the 4th of April 2022, the JAC informed the appellant that she had not been successful in the competition. She sought and received feedback in a letter from the JAC dated 6th of May 2022. It related to the civil and competency aspects of her application and stated that she was selectable, but due to the strength of the competition, she had not been selected. Shortly after the 6th of May 2022 letter, the appellant received a memo from the circuit presiders encouraging people to apply for a circuit judge appointment due to the limited number recruited. As this conflicted with her feedback, the appellant sought clarification from the JAC. On the 24th of May 2022, the JAC sent a feedback letter which encompassed crime, civil, and the competencies. This indicated that the appellant had produced some strong evidence, but had been found not to be presently selectable for appointment. Given this reversal, the appellant sought clarification and/or disclosure of the JAC's reasons. In a letter dated the 8th of June 2022, the JAC confirmed that the selection day panel had determined that the appellant was a selectable candidate in both jurisdictions but stated that the final decision upon which candidates are to be recommended must be made by the Selection and Character Committee, brackets the SCC. In reviewing all the information before it, it was stated that the, quote, SCC determined that overall the evidence provided against working and communication with others was insufficient for the role of the circuit judge, and that, therefore, you are not presently selectable for either jurisdiction, close quote. On the 13th of June 2022, solicitors acting on behalf of the appellant sent a letter before action to the JAC. The proposed judicial review challenge was to the decision of the SCC not to recommend the claimant for appointment to the position of a circuit judge in either the criminal or civil jurisdiction in the 2021 competition. The JAC's detailed letter of response stated that the JAC had made its selection decision at a meeting of the SCC, taking into account all the information before it, including the reports of the panels and the information provided as part of the statutory consultation. The SCC comprises all 15 commissions. 11 were present at the meeting on the 10th of March 2022. The SCC disagreed with the panel's assessment of the appellant in respect of the working and communication with others' competence. The panels had assessed the appellant as a C. The SCC noted that the statutory consultation provided some negative evidence in this competency, which was consistent with negative evidence identified on the selection day. Taking all the evidence into account, the SCC determined that the competency would be regraded from C to D, and the effect of this determination was that the appellant's overall band changed from C, brackets selectable, to D, brackets not presently selectable, with the result that she was no longer selectable for either jurisdiction. Following receipt of the JAC's letter, the appellant issued proceedings for judicial review on the 1st of July 2022. On the 30th of March 2023, Lang J refused permission to apply for judicial review on the basis that her claims were unarguable. On the 6th of December 2023, after a day-long oral hearing, Mr. Justice Swift refused permission to apply for judicial review on the basis that none of the grounds put forward was arguable. He delivered a comprehensive extempore judgment. It is worth reciting in full what Mr. Justice Swift explained at paragraph 8 of his judgment as follows, quote, "Before turning to the merits of the ground, it is important to note one matter. Each ground raises an in-principle challenge. One concerns the meaning of Regulation 30 of the 2013 regulations. The other grounds rest on an assumption that the claimant is wrong on her Regulation 30 ground and the defendant is right on that ground. On that assumption, the claimant's remaining grounds of challenge contend that the approach to Regulation 30 that permits consulted persons, when responding to a consultation request, to draw on the views of others, gives rise to a breach of Article 8, a breach of the principle of fairness, and is an outcome that produces irrational consequences. Each of these challenges also exist at the level of principle. Although the claimant has been prompted to raise these challenges by her treatment at the hands of the Judicial Appointments Commission, treatment which I have summarized and which was very unfortunate indeed, it is not her case, for example, that the specific decision in her case that the evidence relevant to the working and communicating with others criterion was insufficient, was per se either irrational or rested on some material factual error, or was otherwise unlawful. The pleaded case does not invite adjudication on that matter, but only on the in-principle approach to Regulation 30. In substance, therefore, what is in issue is the process used by the Judicial Appointments Commission when considering the claimant's applications. The grounds raised are therefore self-contained legal issues. Close quote. This passage is relevant to what was argued below and to the question of how this case should now proceed. The appellant explained in argument that she had not asked Mr. Justice Swift for more than in-principle decisions because she did not know the basis of the decision that the JAC had made. Outline reasons. I would, as I have already intimated, grant permission to apply for judicial review on each of the grounds considered and rejected by Mr. Justice Swift. It's not appropriate to give elaborate reasons, but I would make the following observations as to why I have reached these conclusions. Fairness. It seems to me that the central issue raised by the claim is whether the JAC is right to proceed on the basis that its obligations of confidence to consultees mean that it cannot, in most, if not many, circumstances, give candidates the opportunity, in fairness, to comment on adverse matters raised by the consultation responses. I should have said many, if not most. That is the issue identified by Mr. Justice Swift as ground 3. I believe that it is arguable that there are circumstances in which the JAC may be obliged, as a matter of fairness at least, to seek the consent of consultees to disclosure of what they have said, or to give candidates the gist of the comments in a form which does not identify the source, such that there is no breach of Section 139 of the Constitutional Reform Act 2005, brackets, the 2005 Act. Section 139, brackets 4, brackets little a, and brackets 5, provide in broad terms for confidentiality in the absence of the consent of the person providing the information. For the avoidance of doubt, I do not mean by those comments to limit the scope of the pleaded grounds, bearing in mind that ground 4 relied on essentially the same points under the heading of irrationality. Whilst that may be a less appropriate denomination, I am content to leave it open to the appellant to argue otherwise. Sir James Eadie, King's Counsel, counsel for the JAC, argued persuasively this morning that a requirement to disclose the statutory consultation to the candidate was not, even arguably, a precondition of fairness. The candidate, he said, could produce their own direct evidence about events which they thought might concern the JAC. The whole structure was, he said, inherently fair and hedged around by safeguards. All aspects could be probed at selection day. The judges administering the process were experienced and well able to put the points to the applicants without breaching confidentiality. In this field, even more than the normal employment context, the confidentiality of consultation was essential, he said, to allow the process to work. These points are well made, but here the appellant was not conscious of any negative points from the statutory consultation having been put to her at the selection day. It could perhaps be inferred from paragraphs 28 to 29 of the JAC's summary grounds of resistance that it was accepted that the matters of concern had not been put at selection day, even in gist form. But this will be a matter that may be better considered at a full hearing. Sir James, very fairly, was reluctant to go beyond the boundaries of those paragraphs or to get into what he described as the, quote, weeds of the facts. It is very much, in my judgment, in the public interest for the fairness of the JAC's procedure to be examined at a full hearing. As the judge acknowledged at paragraph 8, which I have set out above, the appellant's treatment by the JAC was, quote, very unfortunate indeed, close quote. I conclude, as I have said, that it is arguable that there are circumstances in which the JAC may be obliged, as a matter of fairness, to seek the consent of consultees to disclosure of what they have said, or to give candidates the gist of the comments without identifying the source. Article 8. I am, for my part, somewhat doubtful that the characterization of the issue of fairness that I've described as a breach of the terms of Article 8 is likely to add anything of substance to the analysis. It may even serve to complicate it. But I do not think it would be right to prevent the appellant from putting her claim in that way if she is so advised. So I would also give permission on Mr. Justice Swift's ground 2. Regulation 30. The argument on Regulation 30 is, in the briefest summary, that it does not, on its true construction, permit statutory sub-consultation, i.e. consultation by the named consultee with others. The JAC argued that this ground was hopeless, since the regulation itself did not limit who the named consultee could ask in any way. I see the force of that point, but I regard the challenge to the approach adopted under Regulation 30 to be sufficiently closely connected to the fairness of the process as a whole to make it desirable to allow this ground to proceed. Article 14. The appellant seeks permission to add a further ground of claim based on Article 14. I would refuse permission to amend. First, it is highly doubtful whether a case of prima facie discrimination could be established. Secondly, even if the prospect of doing so exists, the issues of justification would be no different from those arising under Article 8 itself. Formulating the case under Article 14 adds complication for no countervailing advantage. Thirdly, the appellant's proposed comparison is with the treatment of a person seeking employment on the staff of the JAC itself. It is hard to see how that comparator is analogous to the position of a person seeking judicial appointment, and also hard to see why the JAC would not treat confidential references for an employee any differently from those for a candidate for judicial appointment. Fourthly, and although this would not be decisive by itself, the point was not taken below. Directions. The parties thought that the substantive hearing would take between 1 and 2 days. I would estimate 2 days out of an abundance of caution. The JAC wishes to file further evidence, but we are assured that evidence will not be huge. Accordingly, I think in the light of the delays that have already occurred in this case, we should retain the case in the Court of Appeal under CPR Part 52.8(6). The JAC has properly expressed concern about the changing nature of the appellant's case. Even before us, the appellant sought to amend paragraphs 1 and 2 of her, quote, details of the remedy sought, close quote, to add the allegations concerning gist and to withdraw paragraphs 4 in brackets, little 5 in brackets and little 6 in brackets, 6 in brackets and 8 in brackets. Paragraph 11 in brackets anyway cannot now proceed, as we will decline permission to amend to include the Article 14 round. I would direct that the appellant produces a final, complete, re-amended grounds of challenge and details of the remedies sought within the confines of the permission granted in this judgment within 14 days. The parties should then agree the remaining directions with a view to a substantive hearing being fixed in this court with an estimate of 2 days in the Michaelmas term 2024. Conclusions. For the reasons I have given, I would grant permission to appeal, and I would make the directions I've indicated. The parties should agree all consequential directions within 7 days of this hearing. If they cannot agree, we will deal with those matters in writing.
I agree.
I also agree.
Good. Well, I don't know whether either of you has anything that you wish to raise.
Well, could I just raise a point just in terms of the scope of permission regarding the fairness ground? If we look at the claim form, the statement of facts and grounds,
which page?
Page number 130. So paragraph 53, the illegality ground, the misinterpretation of Regulation 30. There are 2 sub-grounds as part of that. One is the interpretation of Regulation 30, and then the second one, B, is dealt with as collateral improper purpose. But now, the way that was dealt with by Mr. Justice Swift was that was then dealt with as part of the fairness argument. I just want to be clear that when the amended grounds are amended, whether that improper purpose is or isn't part of the permission.
Shall we hear what Mr. Vaughan says before we express any view, Mr. Vaughan?
I mean, I had understood the improper purpose issue to be part of the fairness argument, but if I've misunderstood that, I stand to be corrected. I mean, it is.
I didn't understand that. One looks at the grounds of appeal. Just looking at the grounds of appeal, Mr. Vaughan, and the heading unfairness, which was the one my lord used in his judgment, effectively it is it's not numbered in your grounds of appeal, but it is effectively 3.
Doesn't say anything about diversity.
Well, I suppose it does refer to 3B. On the other hand, it doesn't in the pleading at A and B say anything about improper purpose.
Yes, I mean, your lordship is right. I mean, 3B is referred to under paragraph 3 of the grounds of appeal, but improper purpose is a species of reasonable, rather than. I mean, it might be said to be separate from unfairness, but the if and to the extent that I think I can say that there is not a distinct argument about improper purpose that is different from unfairness.
Yeah, well, I think you can, and I also think, bespoke diversity strategy is different from the kind of policy that you're talking about in your ground 3, in your grounds of appeal.
Yes.
So, I mean, when you look at 60 and 61, it goes further than, and I mean, I think it's closer to the Bangalore principles point that you abandoned this morning than it is to the unfairness point.
Yes.
But, I mean, just to be clear, I mean, we're not, you know, if when you come to produce a coherent document, there is a serious element of unfairness which has appeared elsewhere, but is genuinely unfairness, then, you know, I think you won't find, anyway, me trying to keep you back in a very tight box. What I do want to be sure is that every point that you wish to make under those headings is included in this document.
My lord, I
I'm
have
afraid within 14 days.
I have that point very clear, and I understand the issues raised by the respondent.
And we do not want, you know, more points or massive numbers of additional. But basically, you know, cases tend to be quite simple at the end of the day, and this one seems to me to revolve around fairness.
My lord, yes, I take that on board.
Okay, is that all right, Mr. Moretti?
Yes, my lord. Right.
Good. Well, thank you both, and thanks also to Sir James in his absence for obviously an interesting day. The judgment will be transcribed, but I will, you saw me just making a few amendments as I went through. I will let you have the draft. It may be circulated, it's not secret, but it is not the definitive version.
I'm great, my lord.